The Honorable, the Supreme Court.
Morning, everybody. Thank you very much. Please be seated. And before you call the case, let me welcome Justice Dooley with Middlebury students. It's nice to have you here. Thanks for coming. And so when you're ready with the live stream, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Miriam Thomas, case number 25 AP 160. Representing the appellant, Paul Thomas, is Chad Bonani. Representing the appellee, the estate of Miriam Thomas, is Justin Brown.
Thanks very much, and good morning, counsel. We'll hear from appellant first, of course. Come on up, please. And if you would, for the record, start by introducing yourself and identifying your client.
May it please the court. My name is Chad Bonani. I represent the appellant, Paul Thomas.
Thank you.
The issue before the court is whether the probate division exceeded its jurisdictional authority by awarding damages, losses, restitution, whatever we're calling it, based on claims, civil claims of breach of fiduciary duty, breach of trust, economic waste. There is
The obligation on the probate judge is to make those determinations of whether or not they're accurate. I mean, doesn't the probate judge have to do that?
Probate judge can, as a threshold issue, can identify issues when they have control over the guardian, when they're supervising the guardian. The probate court cannot take an additional step and actually conduct a trial and adjudicate civil claims.
What changes in the authority of the probate court when a guardian is removed but not discharged?
Thank you, Justice Richardson. I'm glad you brought that up. So there's a distinction here between what a discharge is versus removal. And what appellee argues, and what the lower appellate court, the civil division sitting as an appellate court decided was the discharge is under 2107 when payment is made, but that's actually not correct, and that's not a proper interpretation of that statute. 2107 is permissive, meaning the executor, the guardian, the accountant may, the statute says may, procure evidence of payment and get an exoneration, not required. A discharge actually was decided by this court in probate court versus child under the interpreting the statute of limitations to pursue a breach of a bond under 2755. So if there's a breach of a bond, you may sue the surety within 4 years of discharge. What's a discharge? That was the issue before the court. Is it payment or is it something else? And what the court decided was it can't be payment, because how could the statute of limitations on a breach of a bond run from payment? There would be no breach. A discharge is, in that case, it was dealing with a minor ward. So when the minor reached the age of majority, that's when the guardian was discharged. It could also be when there's a decree settling the account, but it's not payment.
Mr. Bonini, would you agree with me, though, that that a fiduciary responsibility exists for a financial guardian,
I would.
and that a person, especially a person with dementia, who can't take care of her own needs, it's incumbent on this person to do the job at the highest level of responsibility, is it not?
That's correct, yes.
And so doesn't that create a fiduciary responsibility to make sure that it's done correctly?
Yes, and I'm not arguing that there's no fiduciary responsibility or that the probate court doesn't have the ability to protect a ward. And in fact, there was some agreement in this case on the proper procedure. There was allegations back in August of 2016 that there were deficiencies with the conduct of the guardian. And what the parties, what the probate division and the parties at that time agreed was, this is beyond the probate division. You need to go assert these claims, fraud, breach of fiduciary duty. You need to assert those claims in a complaint. The party and give the guardian a chance to respond in an answer and conduct discovery. And that never happened. And then In September of 2016, what the interested parties said at that time was they filed a motion to remove the guardian, and they said, our preference is not to bring those claims now. A proper procedure would bring those after an account, after the guardian's removed and the accounting is filed, and then we can bring those claims. That's correct. You don't have to wait for that. You can bring the claims whenever they accrue, but that's a perfectly adequate or proper procedure. It protects the ward and it gives the guardian a chance to defend the claims.
And in the meantime, the probate action is stayed or at a standstill, or what happens with that?
Well, what happened in this case was the guardian in March of 2018 was removed through a Rule 67 order. And the order set forth certain things that needed to be done. Essentially, stop doing everything you're doing, turn over all your documents, everything to the successor guardian, who was later named in October, and file your final account, which Mr. Thomas did in November of 2018. Turned over everything he had. So then filed his final account. The ward died in April of 2019. Successor guardian, the appellee, filed his final account in June. Probate division approved that in July of 2019. The guardianship is over. If they want to bring claims, they can bring claims. What's being claimed in this case is, well, it was a settlement of account. It wasn't called that at the time. It's called that. They're calling that now 3 to 5 years later, with the benefit of hindsight, because the probate division had been reversed.
But doesn't the probate division have to do a final accounting
Yes,
to close it out?
yes.
And so wouldn't it have to look at the actual figures, determine what's acceptable and what's not acceptable?
So a settlement of account, and this was decided in Relahy, is determining what either an executor, guardian, administrator has in their hands to be turned over. In 2020, when this proceeding happened, the guardian had been removed for 2 years, had turned everything over, was discharged, and he was discharged, and the probate court at that time acknowledged the discharge, because what the probate division did in 2020 at that proceeding was reopen prior accounts from 2010, 2011, 2012. And it did that under 2927. That statute is entitled remedy after guardian discharge. After guardian discharge. The probate court at that time was acknowledging the guardian's discharge. We're going to go back and open up these accounts. And in that, I just want to, if this was an accounting, there was no notice of an accounting. The rules require notice under Rule 66. There was no notice of an accounting. It doesn't reference an accounting in that decision. It references civil tort claims like waste and breach of fiduciary duty, which could be a tort, could be an equitable claim. We don't know, because no complaint was ever filed giving the appellant an opportunity to defend those claims. I want to focus on what the lower court in its order denying the motion to dismiss and finding jurisdiction, what it said in its conclusion, which I think is important. This would be on printed case 20. It said the statutes and rules at play do not point to a definitive result. That is far below what the standard is to find probate division jurisdiction. It's not, there has to be no presumption. It has to be a clear grant. The probate court is limited and special. The jurisdiction flows from an express statutory grant. And the lower court in this case is saying it's somewhere in the penumbra and enumerations of these accounting statutes, but there's no, it's not definitive.
Does the court have ancillary jurisdiction?
It does, but it's limited. It cannot create out of whole cloth an equitable right or claim. It has to be ancillary. And in this case, it was creating, what the lower court said was, this is restitution. It didn't say that at the time. If we're looking at what the court did at the time, and that's what we should be looking at, it said it was damages. We're awarding damages. We're awarding damages under the restatement of trusts. We're awarding damages under breach of fiduciary duty.
So there were misdeeds here by the guardian, however you want to call it. Can you give us a sense of what sort of misuse of funds by any guardian, the probate court would have jurisdiction over? Where do you think that line is?
So I think if the guardian is serving and is not discharged and the probate division has supervisory authority, the jurisdiction or their authority is 3077 and Rule 67. So they can suspend the guardian. They can.
Well, what I'm asking about, what sort of misuse of funds, let's call it, would bring those acts within the scope of the jurisdiction of the probate court in your mind?
So, I mean, if we're talking about, misuse of funds, so if those come before the court in a settlement or in an accounting, the court can flag those, but the court can't say, we're going to award unjust enrichment or something. There has to be a statutory grant for the court.
What's the purpose of flagging?
To put everybody on notice, to potentially suspend the guardian, to coerce the guardian through regulatory measures, to take certain actions, but it can't.
But no remedial action, no order compelling some remedial action on the part of the guardian? No
So,
jurisdiction for that?
so the court can't award damages or restitution. It could cease all actions. But I mean, I guess it depends on the nature of what this misuse of the funds are. Where did the funds go? Are the funds still in the guardian's control or possession? Are they somewhere else? The probate division has jurisdiction over the ward's estate.
And why isn't restitution to the estate within that? I understand your argument about damages, but it seems to me that restitution is a different kettle of fish.
There's no statutory grant for restitution. And what the court did in this case by saying, well, it's in the accounting statute. The accounting statutes under Part 4, Chapter 111 give the court this ability to impart restitutions. It's not there. It's not in those statutes.
What teeth does the probate court have to ensure that the guardian is acting appropriately if there is a question?
Yearly review of accountings, interested parties can bring matters before the court.
Right, but what can the probate court do if something comes before them and the probate court believes that there is an issue?
Remove the guardian, suspend the guardian.
Well, what happens to the funds that have been misappropriated?
That's a claim in the civil division.
Can't the probate judge make it as part of the remedy? Again, you've already said that it's the highest level of responsibility as being a fiduciary guardian.
But under what statute does the probate court get to say we're going to award damages or restitution for this action? What the probate court did in this case was say it was under Rule 917. I mean, we have to find a statute. You can't just say, it should be this way. It has to flow from a statute. And what the probate court did, and I think my time's up. Okay. So what the probate court did in this was say it was under 917 of Rule 14. They said that's where we can award these restitutionary damages. But that section is to regulate when the guardian is serving, not after the guardian's been removed and discharged. And that is also only applies to administrators and executors. And
but doesn't that encourage then fiduciaries or guardians to effectively seal first and apologize later? I mean, if there's no remedy at the probate court, you're effectively saying, what if there's a small amount of money taken, $5,000? How does that justify then a civil action?
I think if the guardian is under the supervision of the court and the estate is under the supervision of the court has that power. But once the guardian is removed and we're 2 years later and the guardian is not holding any property.
Is it the removal and the time, or is it just the removal that creates the lack of jurisdiction?
My understanding is there is no dispute among the parties, the probate division and the lower court, that after a discharge and the guardian's removed, the probate division doesn't have any jurisdiction over that.
You've said that he was discharged. Is that implied from the way in which the probate court went about, or is there an actual certificate that says he is hereby discharged?
There's no certificate of discharge. It's the procedure that affected the discharge, the turning over of all the property in the guardian's hands to those entitled to it. And
But
the
there was
guardianship
no,
ending.
but there was no approval of the final accounting.
There was no ruling on the final accounting. The probate division did not rule on Mr.
So isn't discharge, though, always incumbent upon a completion of the final accounting as well? I mean, it's not just simply because then it's all under the guardian's control. So the guardian can take as much as he wishes from the ward's estate, turn over everything that he has remains, be removed, and essentially say, I'm outside of the authority unless you bring a civil action against me.
A discharge can be rendered by a decree from the court saying, this is what's in the estate, this is what is in the estate, turn that over. Probate division is done at that point. It doesn't have authority to go to the next step. Now we're going to assess these other claims that the ward or somebody else may have and take that extra step. It is beyond, that would be a step too far for the probate court.
Well, if there's something missing from the money, for example, that is accounted for, too bad.
Not too bad. My time's up, but I'll just answer that question. Not too bad. It's recognized that there's a deficiency and here's your claim. You can pursue that claim. There's nothing preventing the pursuit of that claim.
Thanks very much. We'll hear from counsel for the appellee, please. Come on up, and as with the appellant, please start by introducing yourself and your client.
May it please the court, good morning. Justin Brown for the appellee, the estate of Miriam Thomas, the late mother of the appellant, Paul Thomas. Your Honors, this appeal is not about whether or not the probate court has authority to decide civil tort claims and award compensatory damages. This appeal is about whether or not the probate court has subject matter jurisdiction to order the guardian to reimburse the ward's estate for losses that arise out of malfeasance.
Does it matter that the probate court characterized this in some slightly different fashion initially?
Your Honor, as Judge Tomasi characterized it, I think that some of the words in the losses order, the January 2021 losses order, were inartful. But if you look back at the orders that came after the Rule 67 removal order in 2018, and then look at the losses order, and then look at the consolidated final judgment that was entered after this court remanded the first appeal, it's very clear what happened. The Rule 77 order says, guardian, you've engaged in malfeasance. I'm going to remove you so that you cannot do further harm to the estate. Furthermore, I'm going to order a final accounting, and I'm going to require you to produce all the documentation that you have that supports the numbers in the final accounting. And
Mr. Brown, isn't this case about final accounting, the need for a final accounting?
it absolutely is, Justice Cohen. Yes.
I mean, is it any more complicated than that?
No, it's not. I mean, and talk about explicit statutory authority. 14 VSA 3062B says that the probate division of the Superior Court shall have exclusive original jurisdiction over all proceedings brought under the authority of Chapter 111, right? Part of Chapter 111 is the accounting process. Furthermore, 14 VSA 2602 states the probate division of the Superior Court, by which a guardian is appointed, shall have jurisdiction of the estate of the ward and shall alone be authorized to license the sale of the estate and settle the guardian's account. I don't think that you need anything more than that to be clear about what the authority is of the probate court. They alone settle guardians' accounts, and they have the exclusive original jurisdiction to deal with the accounting. And the accounting, I mean, appellee says that a key provision, 14 VSA 2107, is permissive. It's not permissive. What that statute says is that when the guardian has paid and delivered over to the persons entitled to its money or other property in his or her hands as required by a decree of the probate division of the Superior Court, he or she may perpetuate evidence that the money has been paid, right? The losses order in January of 2021 is that decree. It went through all of the evidence. Leading up to that, there were 2 years. The reason there was a 2-year delay between the removal of the guardian and the losses order, because it took 2 years for the guardian to provide all the documentation in support of the accounting process so that the hearing could be had and they could analyze and the judge could determine, was this self-dealing? Was this an exorbitant amount of fees that you paid to yourself? Did you engage in self-dealing? Did you engage in waste? All that evidence had to be accumulated and was decided. I mean, it's so clear that an order issued by the probate court right before the summer of 2020 hearings said we're reopening the accounts of 2010, 2011, and 2012 that had been previously approved.
What's the line, though, between this type of accounting work and the civil claims that would benefit from being brought in the civil division and really are under the purview of the civil division with its rules of civil procedure, discovery, adversarial proceedings?
Sure, Judge Richardson. I mean, they're not mutually exclusive, right? I mean, the bond prosecution statute authorizes someone injured by a breach of the condition of the bond to pursue and prosecute the claim in the civil division. But that being said, that doesn't negate or undermine the jurisdiction of the probate court for the reasons that I just said. It alone has jurisdiction to do the accounting process. And as a practical matter, that's the way it should work, right? The probate court has to issue a final accounting, has to do that before it can discharge the guardian. You need the final accounting to know how much money does the guardian owe to the estate to make it whole. Once you know that, then you go to the guardian and say, I've got the decree from the probate court. In this case, you owe a little over $1 million. Pay it, or the surety on the bond, pay it. And if you don't, then we're going to prosecute the bond. But important, Judge Richardson, to your question, is that one of the conditions of the bond relates to the guardian requirement to settle up the account and pay what's due. So as a practical matter, the probate court issues the losses order. The guardian doesn't pay. That's a breach of the condition of the bond right there. Then you go to the probate court and say, look, the surety's not paying, guardian's not paying. They breached the condition of the bond by not settling up and paying what's due, which has already been found by the probate court. Then that's why it has it baked into it that there's a default judgment that essentially can answer if it's not challenged. Furthermore, for a person injured to immediately go to prosecuting of the bond without the final accounting process, they wouldn't do that, because if they lose, they have to pay double damages, double costs to the guardian or the surety who defends it. So as a practical matter, it's a long way of answering your question. Statutes are clear. You do the final accounting, you find out what's owed. If you don't get paid, you prosecute the bond.
If there is a finding that something is owed, I mean, you could sue a final accounting and say that all the expenses that the guardian used during the time that the ward was alive were legitimate expenses and approve it as is.
Absolutely.
Or you can do it the other way by saying that there were inappropriate expenses and deduct that from the amount of the estate, correct?
Right. Absolutely.
Can I interrupt this hearing for a second? Would you hold this time? Bella, there's a group of pages from the State House out there. Will you help them find seats? I think they're trying to come in, and they saw the students from Middlebury and thought they were, well, thank you, Colleen. Thank you. Okay. You know, it's not often we have so many observers in the courtroom. We like to take advantage of it when we can. Thank you both. This isn't charged against you, counsel. We'll make sure that you get your time.
Thank you. Yeah.
All right. Welcome. Thank you very much. Please, let's continue. All right. Thanks.
Justice Cohen, you're exactly right. And just to follow up on that line of questioning, the appellant just stated that to settle an account is, quote, handing over what the guardian has in his hands. Why would you need a bond to secure the performance of the guardianship if settle an account means once the guardianship is over, all you need to do is give what remains in the account, and there's no authority for the probate court to recoup what has been improperly removed from the account and spent pursuant to waste or self-dealing.
Can you clarify something for me? Are you resting your argument or any part of your argument on the equity, so-called equity power of the probate court?
Yes, Your Honor. I mean, I think we're giving this
This is a
court.
loaded question, so I've got a follow-up, so
Sure.
let me be clear about that. Okay, I'll give you the follow-up. Some of your argument is, now, I happen to read the Redfield Proctor trust case from 1981, which is a very interesting case. And by the way, Tom Hayes was the trial judge there who later came on this court, as you probably know. One of the things I discovered in reading that case and the statutes in Title 14 was that the legislature around that time, and perhaps you're aware of this, I think the section is 2327, they repealed that section. And what did that section say? Apparently, the section said that the probate court may have in equity, quotes, all matters relating to a trust. So how do you respond to what would appear to be a statement of intent on the part of the legislature with respect to this question of equity power?
Sure, Your Honor, but before I answer that question specifically, let me just be clear. So my argument is providing this court alternative bases on which to find that jurisdiction exists, right? I think the first question is you look at the statutes that relate to guardianships under Chapter 11, relate to accounting. Does jurisdiction exist? Yes or no? Yes. I mean, that's the first thing you can do. The second argument, I think, is you look at the ancillary authority, right? Is it necessary for the guardianship statutes to be necessary and effective? Does the probate court have jurisdiction to recoup losses that are caused by a guardianship? I think the answer to that question is absolutely yes. So that's another alternative ground. I think that third, an alternative ground is to look to the administrator statutes, right? So you've got section 2793 states that a guardian shall account for and dispose of the personal estate of his or her ward as administrators account for and dispose of personal estate in the settlement of estates. So I think by that, it incorporates in the administrator statutes, which includes, which the lower court, the probate court had relied on, 14 VSA 917. Finally, as an alternative basis to hold the jurisdiction exists, I'll answer the equity question. I think that this court in Proctor and subsequent decisions makes clear that equitable powers exist in the probate court so long as jurisdiction exists, and it's related to it. And I think that here, because the probate court has exclusive original jurisdiction over guardianships, that as a matter of equity, this court can imply that it has the ability to order restitution, if nothing else in the statutes provide that, because otherwise it's a completely unjust result for the going to the questions that have been asked already. If the probate court doesn't have that power, it has the ability clearly to interview the guardian under oath to determine whether or not the expenses were proper. It has the clear authority to allow accounts. It must have the clear authority to disallow accounts, but if it disallows an account, then what? What's the remedial measure in its power? And if this court finds that none of the other reasons under the statutes apply, then I think it has the ability to order restitution pursuant to its equitable powers.
So a two-part question. One is that the ability of the court under an equity jurisdiction, you would agree, is limited strictly to what it has under jurisdiction, which is to say, simply because it has jurisdiction over one thing doesn't create equitable jurisdiction to start going into another issue.
Agreed.
And to the extent that it has that equitable jurisdiction, it's not a power that can go, well, which is to say, in this case, the individual, Mr. Thomas, didn't object to the hearing in 2020, the 6 days of evidentiary hearing. And he could have raised an objection during that hearing on jurisdictional grounds. And in fact, he could have asked to have this removed to the civil division if he felt that it was not properly in the adversarial, because there is the provision in the probate statutes that allow, by permission of the probate court, if it feels it's gone beyond its jurisdiction, to move to the civil division. Is that correct?
I believe so, yes.
And so in that respect, once the probate court starts acting its jurisdiction, its ancillary jurisdiction under its equitable, it's effectively still following its jurisdiction, but it's going outside of its perhaps narrow lane because of the circumstances. Is that
I would disagree that it's going outside of its narrow lane for the reasons that I've already described. I mean, the statute's very clear that it was well within its lane to perform the final accounting, and you can't perform a final accounting until you know what the amount is owed, right? I mean, to settle something, look it up, I looked it up in the dictionary, right? It's to determine what the final obligation is of somebody and to pay what is owed. And so I think under the plain language, he's well within its lane, but if this court has concerns about what power to remedy a wrong exists for the probate court when the guardian steps clearly outside its lane and engages in malfeasance, I think that a very limited power could be restitution pursuant to the probate court's equitable powers. Thank you, Your Honors.
Okay, thank you. Does the appellant have any time?
Appellant has no time
All
remaining.
right, please call a conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this